Hey everybody, how's it going? Welcome back to Copper Jacket TV. So unfortunately today, I have bad news in regards to California carry. More specifically, SB2 and these sensitive locations. Now, if you guys have been watching the channel for a while, you know that last year we talked quite a bit about May v. Bonta and Carallero v. Bonta. These are two cases that were essentially joined together because they both challenged those sensitive locations in SB2. Well, those were up at the Ninth Circuit Court of Appeals, and we just got a new order yesterday, so we're going to talk about it. Now, since we're talking about carry, if you're somebody who carries to defend yourself or your loved ones, or maybe you just keep something in your home to protect your loved ones, you need to check out attorneys on retainer. Attorneys on retainer is basically an attorney in your back pocket if the worst should actually happen. Now, unlike some companies that offer you third-party insurance as part of your membership, where you call the number on the back of the card and you get some random person in maybe a call center somewhere, attorneys on retainer are actual attorneys. So you call that membership hotline, you speak to an actual attorney, and you get instant attorney-client privilege, and they will be there to defend you through the entire process. Okay, so let's go ahead and talk about what's going on here. So again, we're talking about the case of May v. Bonta and Carallero v. Bonta, two cases that were essentially joined to attempt to overturn the sensitive location aspects of SB2. Now, if you're not aware of what those sensitive locations are, SB2 basically made it impossible to carry within the state of California. I mean, there was virtually nowhere that you could carry once you left your house. It encompassed just about everything, including private businesses. The only way that you could carry into a private business under what we call the vampire rule, because under vampire lore, you can only, a vampire can only go into a dwelling if they were invited. The same applies basically with private businesses. You couldn't go into a private business unless they had a sign specifically posted where people could see that said that people with permits were allowed to carry there. If they didn't have a sign, you couldn't carry there. If it says it was prohibited, you couldn't carry there under SB2. That also included lots of other places like parks and restaurants and doctor's offices and public transit. I mean, there was basically anything that you did once you left your house would have been off limits under SB2. So that was basically the short, unpolished explanation of the sensitive location aspects in SB2. If you wanted to put the whole thing into a nutshell, essentially it made almost the entire state of California a sensitive location, which is clearly unconstitutional and why we got May v. Bonta and Carallero v. Bonta. So with that being said, SB2 was obviously very bad and very unconstitutional. Well, we were fortunate enough to get an injunction at the district court level that barred enforcement of the sensitive location aspects prior to SB2 taking effect. And it did take effect, and unfortunately some of the other aspects of SB2 are just as bad, but at least for a short time, the sensitive location aspects could not be enforced. Well, California being California and doing what California does, they decided to appeal it to the Ninth Circuit Court of Appeals, where it was heard by a 3-judge panel. And that 3-judge panel gave us kind of a split decision. They gave us some wins and we got some losses. Unfortunately, the losses far outweighed the wins. So here's a look at where the 3-judge panel decided you could carry and where you couldn't carry. This is coming directly from the CRPA. It says, here's where we won back your right to carry: hospitals, churches, medical facilities, public transit, gatherings that require a permit, parking areas attached to these places, and the vampire rule. So the vampire rule was allowed to be enjoined, meaning that you can now carry into private businesses even if they didn't have a sign up. That was kind of a big one. But here's some of the losses. These are the things that are no longer enjoined. And this is basically where it stands currently. It says playgrounds, parks, state parks, casinos, stadiums and arenas, libraries, zoos, museums, and parking areas. So even though everything was enjoined originally from the district court, this is the decision of the Ninth Circuit as to what could be enforced and what couldn't. So not only did the Ninth Circuit completely get that wrong, as you can see from that list, there's still plenty of places that are considered sensitive locations, which are completely unconstitutional, but they also came up with their own formula for determining what could be considered a sensitive location. So the Ninth Circuit basically came out with a decision they said was based in Bruin, but flew in the face of Bruin directly. I mean, it was just an absolute cluster F. It was an absolute mess at the Ninth Circuit. And so, well, the plaintiffs decided that they were going to appeal to the en banc panel of the Ninth Circuit Court of Appeals to try and rectify this situation. So we have been waiting for months now to see what the Ninth Circuit would do. Would they take it on appeal? If they did and it went to the en banc panel, it would be like rehearing this case from the very beginning. It would be like rehearing it from scratch. So we were hoping that the Ninth Circuit would take this en banc and fix the issues that happened at the Ninth Circuit where they split up the sensitive locations. Well, we just found out from an order yesterday, the Ninth Circuit has decided not to rehear this en banc. And here's the order right here. It says, the panel has voted to deny appellee's petition for panel rehearing. Judge Sung has voted to deny appellee's petition for rehearing en banc, and Judges Schroeder and Graber have so recommended. The full court was advised of appellee's petition for rehearing en banc. A judge requested a vote on whether to rehear the matter en banc. The matter failed to receive a majority of the votes of the non-recused active judges in favor of the en banc consideration. Appellee's petition for panel rehearing and petition for rehearing en banc docket number 80 is denied. Now, while this is very disappointing, it's not really surprising from the Ninth Circuit. It's yet another way for them to give the finger to the people of California. We wanted the en banc panel to take this and correct the errors that were made by the three-judge panel. And there were, in my opinion, plenty of errors that were made. This is not the end of the case. There's actually a couple different directions this case could go in right now. So obviously this was sent up to the Ninth Circuit based on an injunction from the district court. So they were basically hearing the injunction. They decided to uphold some of the injunction and overturn other parts of the injunction. They could take this case back down to the district court and ask for a final judgment from the district court. And that would kind of more solidify things. Instead of it just being based on the injunction, it would be based on a final decision from a federal district court judge. Or they could decide to take this case now and this injunction up to the Supreme Court. So again, while they decided not to take it en banc, and while the sensitive location aspects of SB2 stand the way that they were given by that three-judge panel, it's not the end. So again, we have two choices. Go back down to the district court and ask for a final judgment, or take it up to the Supreme Court and ask them to figure things out. So again, unfortunately, because that order came out yesterday denying the rehearing en banc, the sensitive locations in California that stood yesterday are the same that stand today. There are still a bunch of different places that you cannot carry under SB2 in the state of California. And until anything further happens, either at the Supreme Court or the District Court, it's just going to remain the same for now. And that's something to consider when you think about the bills that have been introduced in Congress, like national reciprocity. If national reciprocity becomes a thing and people from other states are allowed to carry in California, they would still have to follow California's sensitive location laws. And that could be a big problem, especially from people that come from states like mine that don't have these stupid sensitive locations, which is absolutely ridiculous. They go into California and they might be surprised you're in a parking lot of a zoo and you can't carry in a parking lot of a zoo. Or you can't carry in the parking lot of one of these, sensitive areas. It's just a complete mess. And once again, the Ninth Circuit has failed the people of California by not taking this en banc. So I wanted to let you guys know about that. It's terrible that it's happened. I was really hoping that they would take this. But we'll see what happens and what the CRPA decides to do from here. And hopefully, we'll get a victory in the end here, because it's just, it flies in the face of Bruin. It's completely unconstitutional. So hopefully we get a win in the end, but this is just going to drag it on even further. So I wanted to let you guys know about that. I want to thank you all very much for watching. If you haven't done so already, please consider hitting that subscribe button. The like button is always appreciated. And that little bell notification will let you know when new videos come out. You guys have a good one.